Sound Jai Shri Krishna, Jai Chinendra, Jai Swami Narayan, and good evening to you all. Namaste, good evening, everyone, okay? Okay, on behalf of GAA London, I warmly welcome you all tonight's. Let me switch the music off, I think it's best. That's better. On behalf of GAA London, I warmly welcome you all to tonight's health and well-being presentation, focused on a very important and practical topic, financial well-being. As part of our commitment to empowering the community with knowledge and peace of mind, this evening's session will help you understand crucial aspects of financial planning, estate matters, and legal preparedness, which are often overlooked but absolutely essential. So our session is led by Mr. Mahesh Solanki, a respected advisor with a wealth of experience in financial matters. We are also delighted to welcome Nirali and Matthew from AWP Legal, who will be guiding us through the legal aspects of wills and power of attorney. The session will also include an interactive Q&A, so feel free to note down any questions you may have in the chat. We encourage everyone to stay engaged and make the most of this valuable opportunity. So before we begin, everybody, see this finger? Put your finger on your camera and switch the cameras on, because we'd like to be active with everyone. Am I right, Maheshji? Can't hear you. Oops. Can't hear you.
I have a message which says my camera has been disabled by the host.
Oh no, sorry about that. I didn't want to do that. I don't know what.
I'll do that for
God.
you.
I don't know what happened there. Asked to start
Can
video.
you do that now, Doris?
I'll try.
Doris, try
Yes.
please. Yeah.
Okay.
Yeah,
Yeah,
that's
there you
it.
are. There you are.
Maheshji, it's all yours.
Okay, I was expecting Kamlesh to do a bit of intro also. I see.
He probably is engaged on the phone. He will
Is
join
he?
in.
Okay.
He will join in.
Good evening, all. My name is Mahesh Solanki. I think if you were here at the last session last week, just to tell you a little bit about me, I've been a financial advisor for the last 35 years. So I've got a wealth of experience in financial matters. Last week we discussed a couple of topics, mainly to do with inheritance tax planning and retirement planning. We touched a little bit on estate planning, but I said, no, we'll leave it for today. So today, obviously, we're going to be discussing on estate planning. And one minute. Yes. I've also got Matthew and Nirali, who are associated with our company. We pass all the will writing or trust business to them, so they can look after my clients in that respect. But before that, let's talk a little bit about what we discussed last week. We touched on inheritance tax planning. What were the implications? What were the allowances allowed? And all that. If anyone do have any questions on that, please, by all means, you get in touch with me and we'll talk about it. On retirement planning, we also discussed about various aspects of how to mitigate the forthcoming, maybe the IHT on your pension fund when it passes on to the beneficiary. This rule is supposed to come in on 25th on April 2027. Nothing is concrete at present, so we'll just wait and see what happens with that. Coming to this evening, estate planning. Well, estate planning means working out how you would like your assets to be managed and passed on after your death. First and foremost, obviously, making a will. By making a will, you obviously do three things. One is make your executors and loved ones' lives easier, protect your estate for your beneficiaries, and help you understand how much inheritance tax might be due. Uh, that's the basic structure of estate planning. Now, first and foremost, obviously, the most important part is wills and trusts. So, on that issue, I would like to pass it on to Matthew and Nirali, and they can talk to us more about wills and trusts. Matthew?
Kamlesh Ji is
I'm
there.
wrong.
So,
Yeah,
Kamlesh?
yeah. Before we pass on to Matthew and Nirali, can I take a few minutes of people's time, if you don't mind? So, look, we talked, and Mahesh has kindly covered what the topics we looked at last week, and inheritance tax is a sort of a very complicated area, and the guidance that we gave, and the purpose is to raise awareness and give people guidance, and really everyone's situation is very, very specific. Some people are sort of, have a low asset base. Some people have a very high asset base. So you have to seek advice on this. Okay. And I think that's very important you do that. And what I wanted to do is share with you some of the sort of the themes we got after our call last week. We got some brilliant feedback from the session. Thanks to Mahesh for leading a good session. And it raised lots of questions. And there were three groups that reached out for additional advice and information. And I want to share with you just the themes of those three groups. Okay. So we had individuals who reached out to us who are in their 30s, 40s, who've got parents, and they were worried about if their parents have done any estate planning and inheritance tax planning. So they've reached out for advice. We've asked them to speak to Mahesh directly. And in these cases, the children are attending sessions with their parents because, fortunately, a lot of Indonesians have become quite affluent over the last few years. Their asset base is very, very high. Okay. And they don't know how to manage their estate. So we had a group of people who are young, 30s, 40s, who want to know how they should advise their parents. And we've given them some direction and they're coming to see Mahesh for some guidance. The second group we had was women. We had women who have separated, who have become widowed, and the level of financial sophistication is a bit limited. Not their fault. The husbands may have managed their finances, etc. So they've reached out asking for advice and direction. Again, they've come to Mahesh. So there's a group of people there that could benefit from advice because sometimes there's lots of assets there, they're not sure what to do. Okay. The third group, well, there's very few of them actually, there's only one, but had a substantial asset base, a retired pharmacist, had the freehold of his pharmacy, he's got property abroad, and basically the estimated tax bill was approaching £2 million of inheritance tax, and he had done nothing. Okay, so the session we had last week just raised awareness, and he's reached out to us seeking advice. So my point to all of you, everyone's circumstances are very, very different. I've shared with you three themes that we've seen after last week's call. My advice and recommendation is please, please, please reach out to Mahesh. You've got the contact details. Mahesh, can you just remind people how your fees work, please?
Okay, my fees are very, very straightforward. The first half an hour is completely free. During that period, we will be able to establish what would be the possible requirements for the client and whatnot. And if the client wishes to proceed further, then we go into a full fact find session. And for that, we charge a fee of £150. And that's basically is purely for admin purposes. And the fact find will give us a pretty good indication of where the client's position is, what kind of recommendations we can give them. If there are any recommendations, if the client is happy with any of them, if they wish to proceed with any recommendations, then that £150 is refunded, and we would then be able reimbursed by whatever product we recommend to the client. And that's basically it. Very simple.
Good. So I'm going to summarize that because I think it's worth knowing. So many IFAs will charge most probably £200 to £300 for their first consultation. Okay. What Mersh is saying is his first consultation is free. Okay. And that's highly appreciated to have that discussion. Should that progress to a fact finding, once you've sort of look at your assets and your beneficiaries and where your estate is, because everyone's estate is at different stages, then there may be a cost, but the cost can be reimbursed if you take out any of the insurance or investment policies. So, in a way, it costs you very little to reach out to someone like Mesh, but it could save you thousands, hundreds of thousands of pounds. So please think about that. And one last thing before we hand over to Matthew and Nirali, we also discussed last week that people are, especially, of an Indian persuasion. I know there's other communities there, but I can talk to our own communities. They're very, very reluctant to disclose their financial affairs. And we said the only two people that get to know about the financial affairs tends to be the taxman and your lawyers. And at that stage, it's too late to do anything, right? So you've got to open up to people. So I just want to leave you with that thought. And I think now, Mesh, I think it's fair to hand over to Matthew and Nirali.
Yes. Matthew, over to you.
Thanks, Mahesh Bhai and Kamlesh Bhai, and appreciate being able to be on here today. It's an excellent chance to just present some information that you've both touched on already, where there's so much uncertainty out there. People want to make decisions. They don't know what decisions to make. They don't know which way to turn. They don't know who to get advice from. And as you've very correctly identified, Kamlesh Bhai, people don't necessarily want to talk about what they have, their estate, what money they have, where it is, and things like that, until it's too late. And unfortunately, we come across that every week when we're meeting with clients, where had decisions have been made a bit earlier in their life, even a few years earlier, then things would have been a lot easier. So definitely encourage everyone to do that. I think one of the main things that we often find is that people are asked to make decisions and they don't know what they're trying to make decisions about. And one of the things that we do as a company based here in Northwest London is to try and educate people, go out into the community and help them to understand the sort of decisions that they need to be making before you can even start putting pen to paper. Now, that applies to every single one of us here on the call and everyone in the community. Just going to start off a little bit by talking about power of attorney, because that's something that's becoming more and more critical in lives in the days that we live. And Nirali, you're going to just say a few words about that for us.
Hello, everyone. Just touching back on what Matthew said, yes, lasting power of attorneys are becoming very important. You may have either know someone or have heard that when someone goes into some kind of care, or if they're unable to make the decisions for themselves, so lose mental capacity, then things become very difficult for the families, for the loved ones. Or it can be a situation that, they have gone abroad, they have moved back to the country of origin where they come from, and they want things done here because they own assets here, and they're unable to manage those. So whatever the situation is, as a general advice goes, we would recommend that everybody that's over the age of 18 have a lasting power of attorney. Now, I'm not sure if everybody knows that there are two different types of lasting power of attorneys. One that deals with property and finance, and one that deals with health and welfare. Both of these power of attorneys will work independently. The reasons for doing these power of attorneys are so that you choose at the time that you have mental capacity, which is now, of the person that you trust the most, or you want the person to deal with your finances or your health and welfare decisions. It's your choice. It's not left to the court of protection to then pick someone out there, whoever it might be. It may be a company, it may be an individual that doesn't know anything about you, it may be a family or a member of the family that you really don't want to deal with your personal finances or your health decisions. So making the lasting power of attorney now, whilst you have mental capacity, is very important. We always say, we always hope that you never have to use it, just like a car insurance. We all have it. You know, the day we need it, it's there. In terms of power of attorney, once everything is completed in terms of the dedicated attorneys, the person who is given the permission, it then goes off. Well, once everything is signed, it goes off to a government office called Office of Public Guardian. It then gets registered there before it's returned. Now, that can take time. It can be anything from, currently we're working on 8 to 12 weeks. So it can vary depending on each client, but it is, like we said, it is very important for you to have it. Hopefully you never have to use it. If you have any questions about that, please either drop them in the chat box or we can have a little chat later. I'm going to pass it back on to Matthew for a further information on wills and trusts.
Yeah, it's great to be able to work with you, Mahesh. And I think it's really important that everyone has people that they can turn to for advice. Now, a lot of people here on the call today might say, well, I have a will. But when you start digging into what's in your will, do you know what's in your will? Can you remember what's in your will because of when it was written? Maybe it was written 10, 15, 20 years ago. Obviously, legislation changes, and that's one really important thing to remember, is that the law in England and Wales is the same for everyone, but how it applies to you and your individual married couple or family circumstances can vary from every single person here. And that's why it's important to get that professional advice, to sit down and work out what you have. Like Mahesh was saying before, what is your asset base? What do you want to do with it? And why do you want to do that? And is it something that will be considered slightly out of the ordinary? Is there someone in the family who may want to challenge that will? Because if these problems can be discussed and addressed now, then it saves, as Kamraj said earlier, it can save the family and your loved ones a lot of stress, anxiety, heartache, and a lot of challenges in the future when they're dealing with HMRC, when they're dealing with an estate. And I think that's one really important perspective that we put on things, because we also do probate. When you're looking at putting a will together, you have to look at the end goal. So yes, we don't want to think about that day when we pass away or when our loved ones pass away, but we're trying to write a will that addresses what can happen at that point in the future and minimize the burden on the family and the loved ones having to deal with that. Just some little pointers that we include in wills that not all will writers do. When you're choosing an executor to administer your will, we would generally always recommend at least 2, and potentially some in reserve as well. Because I'm sure some of us in the room today have got a will that we've written, but do we know if the executor is still alive? Do we know if that executor is still capable of executing your will? Having someone in reserve is really important, because it saves any problems when you actually get to that point to actually have to execute that will. Other things include when you're addressing beneficiaries. If you're giving specific gifts or legacies from your estate, if you're gifting your property, do you understand the implications? Do you understand the inheritance tax implications of what you're wanting to do? Is there a better way to do it? And if you have, say, children and you're gifting your assets to your children, then does your will actually stipulate, well, if on a very sad occasion my child predeceases me, is there another layer of beneficiaries in there? Are you thinking about next steps down the line? Are you thinking about grandchildren? Are you thinking about charities? Are you thinking about alternatives? Future proofing your will like that, making sure that you've got 2-3 steps covered, can also reduce your inheritance tax liability and can reduce problems. We don't want any part of your estate. So just because you have a will that's written, if there's a potential problem or if part of your gift isn't able to be gifted, then part of your estate can actually be classed as intestate, even though you have a will when you're addressing probate. There's so many complexities. And like I said before, that's why you look at an individual and a family circumstances and then work out what's the best way to do it. And that's what you have to do. Just like with Mahesh Bhai, when you're looking at someone's finances, trying to work out what's best for them, it has to be tailored to that individual or to that couple when you're writing a will. So just some tips and ideas about why it's so important to ask questions. We want you to ask questions. Like Mahesh Bhai, we also say, ask questions of us. We don't have a problem speaking to anyone in the future. Sorry, GAA, you had a comment there.
Sorry, I just would like you to, for benefit of others, what is the difference between a will and a trust? Can you explain to them, please?
Yeah.
Because that way they will understand more.
Yeah, definitely. So there are many different kinds of trusts. You can have what's called living trusts, which come in different forms, and those trusts exist now whilst you're alive. Now, there are a few reasons for doing those, but there's a lot of things in the media at the moment encouraging people to do living trusts. We always exercise a lot of caution when looking down that route. One of the main reasons for exercising such caution is they're not hugely tax efficient when it comes to inheritance tax. Because if you put assets into a living trust, when one of the beneficiaries passes away, that has to come out of the trust, so it doesn't protect it from inheritance tax. And the trust owns the asset, not the individual. So you're very limited as to what you can do with an asset once it goes into a trust. So generally, we shy away from living trusts for that reason. They do have their place, and they do have certain circumstances where they are useful, but to be used with extreme caution. We use quite a lot of will trusts. So that's essentially trust wording that's written into your will, but that doesn't come into place until the time of death. Now, a lot of these trusts will include things like a property protection trust, flexible life interest trust to protect multiple assets. That comes in for a married couple, that can be very beneficial because that comes into place on first death. The trust is set up. It protects the asset, generally the main residence or the principal private residence of the individual. And that protects from a few different things. That protects from what we call sideways disinheritance. Sideways disinheritance is where the surviving spouse remarries. Now, if you've transferred all of your assets to spouse on first death, then that spouse remarries, then where are those assets going to go? They're likely going to go to the new partner. Now, if you have children, then what are they going to benefit from? You are also looking to protect your assets and your hard-earned money and your investments from care fees. Now, if the surviving spouse has to go into care and 100% of the property, for instance, is in your name, then the local authority social services will be looking for you to liquidate that property if you don't have the cash to be able to finance your own care. And for inheritance tax as well, there's the residence nil rate band, which is an additional allowance of tax-free amount of £175,000, which is only applicable if you leave your principal residence to a lineal descendant. Lineal descendant only being children or grandchildren. If you leave that to spouse, then you risk losing that additional 175. So those are three main reasons why we use trusts in the will: to protect the assets, to protect your family. There is another kind of trust that we use infrequently. If you have someone in your family who you're gifting to, and they are what we call vulnerable. Now, that vulnerable could be a medical condition. It could also be that they have mental instability. It could be that they have other problems, so alcohol problems, drug problems. You want them to benefit from your estate, but you know in the nicest possible way they can't manage what they're going to receive. Then we use what's called a vulnerable discretionary trust. So they can still have the benefit of that money, but the trustees that you nominate in your will essentially have the guardianship or care over that money, so that can be spent in a wise way, obviously looking for the long-term benefit of that beneficiary as well. So lots of different trusts available. Again, depends on your circumstances, depends why you need a trust. Do you need a trust? Some people have trusts written into their wills. I met with a lady on Tuesday this week. She had a trust that was recommended and written into the will that she didn't actually need because it didn't actually provide any benefit to her. So we don't recommend trusts if they're not necessary.
Cool. Matthew and Nirali, can I ask you a question? It's one that's raised by a member of the sort of the attendees. So, cost, powers of attorney. Can you give us a feel, Nirali, of typical costs? I know you can get them off the shelf in terms of powers of attorney, but what would you say a typical cost of drafting powers of attorney? And should we draft them for free, off the shelf?
I'll take that one if you want, Kamlesh Bhai.
Yeah, sure,
Yeah,
please.
so firstly, just to address the point, yes, you can get them directly on the Office of the Public Guardian website. It is possible to do that. You can get it, set it up, register it, and all you pay at that point is the £82 per LPA for registration purposes.
Yeah.
However, we always exercise caution with that for two main reasons. A standard power of attorney, if you have assets that are in discretionary managed funds, the discretionary fund managers, currently the bigger ones in the UK, will not accept a standard power of attorney unless there is additional clauses inserted into that which allows the attorney to act and instruct those discretionary fund providers. I know it's a bit of a mouthful, and we can clarify that if necessary. Other things we also insert, so we insert quite a few legal clauses into the power of attorney. One of the other common ones is grandparents will often gift grandchildren on their birthday on a regular basis. So say every year you might gift, if you have a grandchild, you might gift them £200 on their birthday. Having that, an additional clause written into that power of attorney, allows the attorney to carry on doing that even after the donor has lost capacity. So yes, you can do them online on your own, but you do need to be careful about doing that because it doesn't necessarily give you all the permissions, the legal authority to be able to do the things that the donor was doing before without these additional legal clauses in. We sit down with the Office of Public Guardian once a year and we go through where things are at, what updates they're doing, and we also review with them the legal clauses that we're using. And we've never had any challenged yet, but there are a lot of challenges in power of attorney, and they do refuse power of attorney and things like that. With a certificate provider in a power of attorney, they're also bringing in restrictions this year about who can be a certificate provider. It can't just be anyone. It can't be necessarily be a next door neighbor. They're looking to make that a sort of a more of a raised profile in terms of who can be the certificate provider, because the certificate provider is essentially signing off that the donor and the attorneys, one, have capacity, so the donor has capacity under the Mental Capacity Act to actually give authority, that the attorneys have capacity, and the attorneys, for instance, have never been bankrupt or subject to a bankruptcy order and things like that, which is also needs to be taken into consideration.
Okay, so just to repeat, people can get off the shelf powers of attorney and they pay £82 for registration. The better route is to take, proper advice, because everyone's circumstances are different and there could be nuances. So for AWP to advise someone, and I know every single circumstance is different, for powers of attorney, what would be an approximate range of fees, please?
So one thing that I didn't mention before, we work on fixed charges. So everything is fixed. We have a price list which we send out to everyone, which has got all the charges on there, and you will never be charged more than what's on those price lists. We don't charge any hourly rate work. Just another feature of AWP which figures into this is we do all of our appointments in person at the client's home. So we will come to you and we'll sit down with you and we'll discuss what your circumstances are, and then we will work either the will or the power of attorney to do that. We'll produce the drafts, we'll send you those for checking, and then we'll come back to your home to sign everything off with you. So everything is done in person in the comfort of your own home. The fees that we charge include all of that. For a single person, 2 power of attorneys, we charge 640. And for a married couple, which is 4 power of attorneys, is 910. And I know personally, and I'm not just saying this, I know there are companies, we got referred to a company just this week who charges just over double what we charge to do the same thing.
Look, I think, and the reason I ask this is because Indian Asians are always looking to find out what things cost. Okay.
Of course. And it's a very sensible question.
And look, for the audience, that £640 for 2 powers attorney sounds like a lot of money. £910 for 4 powers attorney for a couple sounds like a lot of money. We've seen situations where people lose more than that by not being properly advised. Okay. The powers of attorney have been incorrectly drafted. They've been drafted while a person doesn't have capacity. So really fraudulently. Okay. We've also seen situations where wills, children have taken their parents to a lawyer, had the wills drafted, but the parents didn't understand what the will was about. Okay, so you need to, for example, they didn't speak English, they only spoke Gujarati, the lawyer only conversed with the child, and the parents didn't know. That will got invalidated, but it took an awful lot of time, awful lot of, arguments with the family, the siblings. It caused all sorts of issues. So the sooner we take better advice, and do take the proper advice, because people always look to save money at the end of the day. For the sake of a few £100, you can save yourself a lot of heartache, and actually a family heartache. I would definitely not look at the cost as a cost issue, more as a benefit issue. Okay, so I think that's really useful. Matthew,
just want to interrupt you briefly there, Kamlesh. So
Sure.
AWP Legal can also help with the language. So Nirali, who's sitting here, is fluent in Gujarati, Hindi, Swahili, and what's the other one? Punjabi, there you go, and English. So as a company, we can offer those services in all 5 languages. Obviously, the documents themselves are in English. And just on the power of attorney from April this year, they haven't publicised it, but if a power of attorney is submitted to the Office of Public Guardian and it's incorrect and they send it back to you, they will ask you to resubmit, but when they do that, they will ask you to repay the submission fee again. That just came in April this year.
I understand. There's a question that's come through. It's from a lady, Meena Shah. She's asking, what is a deed of settlement? Is it valid after 25 years, and can it make a will invalid?
It depends what the deed relates to, and it depends who the parties are of it. I know it's a very generic comment. I would need sight of it to see what it related to.
Can I ask people to keep sending their questions through by way of chat? If you don't want to speak, that's totally fine. But put it, send them through by chat, and we'll sort of take them one by one. As someone's asked the question: is the fee for each power of attorney or both? And Matthew, maybe just worth repeating what that fee is.
Yeah. So for one person, you get 2 power of attorney: property and finance, health and welfare. So for one person, that's 640. For a married couple, it's 910, and that's 4 powers of attorney. So 2 property and finance and 2 health and welfare. Anyone who wants our price list can have it. That's not a problem. And you'll see on there, there's 2 columns, one if you're a single person and one if you're a married couple.
Questions coming through now. So does a deed of gift require registration? What is the process?
Again, it depends what the gift is. If it's a property, then often it does require registration. If it's individual assets or money, then not necessarily. But again, that's something specific we can look into.
Great. And the question was raised by Praful Soni. I mean, Praful, do you want to expand on what you've put? Do you know, is it a specific or is it just a general question? Okay, we'll take silence that they don't want to go on tape. Cool. So
There's a question from Panna. Panna wants to ask us a question.
Sorry, Praful Soni has just come back saying the funds were given to purchase a property. So if the deed of gift was to purchase a property, I'm guessing, Matthew Nirali, this requires registration.
Yeah, it more than likely would, because there are a number of implications with that in terms of gifting and who's going to be living in the property. There's a few variables in there as well.
So the answer is generally yes.
Yeah.
Muji's come back with a question asking whether a power of attorney can be given to a single person or can it be given to more than one?
So the minimum is 1 attorney. The maximum is 8 attorneys. Now, you can have reserves as well. Generally, you do up to 4 primary attorneys, and then if you wanted to, have others in reserve as well.
Yeah. And is it possible to give, with the health power of attorney and a financial power of attorney, can you make the attorneys different on both of those? Do they have to be the same?
Very good question. You can make them different, and people who have businesses, sole traders or company directors or even partnerships, we would always recommend that is also addressed in your property and finance LPA. However, if you don't wish to have the same attorneys on your personal finances compared to your business finances, you can create 2 property and finance LPAs, one just for your business and one for your personal as well.
Great. Anna, you've got your hand up.
Just to encourage everybody else to know what happens if someone passes away without a will in the UK.
Okay, very good question. Essentially, they are classed as what's called intestate, so dying without a will. After that, it depends very much on their family circumstances. There is a set structure about how your estate is distributed. If you're married with children, the first £322,000 goes to spouse. And then the balance of what's left, 50% of that also goes to spouse, and the rest gets distributed in equal shares between the children. If you pass away and you have no spouse and no children, then it goes back up to your parents. If your parents are not there, it goes to siblings, and then back down the tree again.
And just to confirm, Matthew, so if there is no will, it goes to intestate. The spouse doesn't get 50%. They get the first £322,000, and the rest of the estate is then given 50% to the spouse and then to the children.
Correct. Yeah.
Right. So this is very, very important for people to know. Most people may think it'll pass to, the surviving spouse. Not the case. So, and we mentioned the statistic last week. Around 45% of people have wills. So less than 50% don't have, more than 50% don't have wills. Is that correct stat, Matthew?
Yeah, it's about 58%. I think it is something like that. At the moment, I don't have a will.
No.
And the government in the next 12 months is scheduled to earn about £9 billion in inheritance tax.
Yeah.
And a lot of that is because people don't have wills. A prime example, my next door neighbor here in Harrow, I was talking to him last year about putting a will in place.
Mm-hmm.
He had a massive heart attack just under a month after that conversation and passed away. Now, because he didn't have a will, his estate ended up paying just under £300,000 on inheritance tax on first death. His wife is still alive. Had he have had a will, the estate wouldn't be paying any inheritance tax.
Very important, very important.
So
Any
there's
other questions?
also point to mention here with cohabiting couples, no spouse exemption applies, just so you know.
Can you explain that?
So if a person's living, two people are living together
Yes.
and they're not married or civil, or they don't have a civil partnership, then the spouse exemption will not apply. People are under the assumption that, you know, oh, I will, because we're living together, we will get something. But it doesn't work that way. You have to make a separate claim to say that we have been living together. And because they have been living together under that rule, it's a completely separate piece of legislation. It's got nothing to do with spouse exemption. And, you know, what you will get will depend on what the judge or who the judge is on the day and what the circumstances are.
Yeah. And that can be a very drawn out process for people.
Correct.
So, you know, I think that's really important to understand, especially in the world we're living in, where we're seeing people separating regularly, unfortunately, but regularly, people passing,
Yes.
and people are getting into relationships again.
Yeah.
And the passing of assets becomes hugely complex.
Yes.
You know, people talk about, you know, bloodline planning and passing on to children and their children's children. If that's what you want to do, the assets, you have to do this soon and take advice. And if you're going into new relationships, again, take that advice, because your circumstances will change.
Yeah,
right?
because when you're married and you separate and then you get remarried again, you've then now got stepchildren or adopted children. Now, all of those children, including foster children, now have a right to claim on your estate. So if you haven't made a will, automatically the judge will say, well, who are your children? How are they related? And the distribution takes place that way. You may be in a situation where, you know, it may, hypothetically that we speak, that, you know, the monies that you've earned have come from your parents, and you only want that to go to your children and not the stepchildren. Unless you make a will, it will be distributed according to how the judge wants it distributed. So again, it gets taken out of your control, and the judge will make that decision based on the information that's given to them. They don't know you. They don't know what your family dynamics are. They don't know how and why you made, you know, you wanted these things to be in place. And this is where we highlight all of these situations to our clients, to the community, to say that, you know, having a piece of paper when you're not there is more valid in the court of law instead of my word against yours.
Yeah.
You can do that to protect someone. You can do that to disinherit someone. That's absolutely fine. You know, there are families out there. There are situations that we know of where, you know, children are fighting, they don't talk to each other, or one's got more than the other, or one has already been given the inheritance in terms of, you know, has received 300, 400,000 pounds, and the balance needs to go to the second child. But when it comes to the time of death, if that's not written or nothing is in paper and signed, the judge will again say, I'm really sorry, but it has to be distributed again. So what you're doing is disadvantaging the second child from inheriting what they are actually supposed to inherit.
Brilliant. Yeah. Look, great advice. I was going to ask, with the powers of attorney, I'm sure the question will be, well, how much are you going to charge in your fixed fee schedule for drafting up wills for people? And I know you do personal consultation, in-personal consultation. You do it in different languages, but can you give us again a range of what the fees would be for that, please?
So for basic will, for one person, 310, and for a married couple, 390. Trusts are on top of that, depending on what trust it is and what, trusts vary. We do trust packages. It's very common for people to do a will with trusts and do powers of attorney and do it all at the same time. And we do package prices for those, depending on what trusts and package you need.
Yeah. And I mean, I think that's good value, but a point has been raised on this chat to say that there are charities where they have participating lawyers that can do wills at a reduced cost. What are your thoughts on that? Are they the qualified lawyers, charities sort of endorse them? Is that a good path for people to take?
It can be. One note of caution from our encounter for people who have used them before is they act on instruction. So if you tell them what you want, they will generally write that into a will, but they won't ask you questions about why you want it, what your circumstances are. I would say probably 75% of our client meetings, we'll sit down with the client and they'll say, well, I want to do this, this, and this. And we'll say, well, yes, you can do that. But if you do it this way or that way, then it will be more tax effective and you achieve the same end result. So you don't get that consultation process and go through it and with the charity style ones. And often a lot of those charities specifically request them to be a reserve beneficiary on there, should all the beneficiaries predecease or not be available to collect.
Yeah, and thank you for that. I think that's really good. So basically, it's the consultation and advice that's the extra layer that gets added.
Yeah.
I have another question that's come through, and the question is, what is a property protection trust?
A property protection trust is a will trust, so it gets written into the will. And generally, well, we only use that for a married couple. And it's a trust that gets put into place on first death, and it places the primary residence or 50% of the primary residence into trust, therefore protecting against the things that we mentioned, against care fees, sideways disinheritance, and protecting the residence nil rate band for the person who's passed away.
Yeah, it sounds like that is a must, right?
Yeah.
Yeah, I mean, just the three benefits you get straight away by having that in place, justifies people going down a property protection trust, draft into the will.
Yeah, it's probably the most common trust that we use at the moment.
Yeah. Panna, you had your hand up.
Yes, I think this is for Nirali. When you were saying about a couple who had not been married and they've been living together for 10 years, and within those 10 years, they've had 2 children. So what happens in this case when one leaves? And
When you
one
say
goes-
one leaves, as in they're separated or
No, gone,
divorced,
up there.
passed. Okay,
Passed
so
away.
if you have a cohabiting couple and they have what we call lineal descendants together, they haven't written a will, then the intestate rules will apply, which basically means that the 322, isn't it? The 322,000 pounds is tax-free, the first 322. And because they're not married, automatically all the assets will go to the children. But at the time of doing probate, the cohabiting partner, can make a claim against the assets to say that under the cohabiting rules, because I live in this house and this is my primary residence, I need something as well. But like I said, it all depends on the judge on the day.
Okay. I was told that if two of you have lived together for over 10 years, automatically you're known as life partners.
No,
No,
No.
no,
that's not true.
no,
That's
that's not true. No.
Thank you.
You need that piece of evidence, that marriage certificate that says that, you know, marriage
Yes.
certificates or civil partnership that says
Mhm.
we are married. And
Yeah.
these documents are provided, they are asked for, the original copies are asked for at the time of probate. So the Court of Protection
Because
will look at all of these documents, they scrutinize them before they even come back to us and say, yes, we will grant it.
okay, because when I question like that, it's only a piece of paper. What do you say to
Yeah.
that?
That piece of paper carries a lot of weight.
Yes, absolutely. Thank
Yeah,
you.
it is. It is only a piece of paper. And to be quite honest, you know, at the time of signing that piece of paper, mental capacity is not checked, but the consequence of it is bigger than signing that piece of paper. So, you know, you've got to choose what happens. You know, we have, this is a live client that we have who was previously married. He then got divorced from the partner, got remarried. Something happened in between, but with the paperwork, and police raided their house. They found the paperwork, and then they said to them that this is not valid. So at that time, this was going back 20 years. At that time, this new wife was like, yeah, okay, I will do something about it. Never did anything about it until we got there to do the will, and then they showed us the document. Now, the problem is that the divorce paperwork, the date on the divorce is after the second marriage, which voids the second marriage
Absolutely.
automatically. Without you doing anything, it voids the second marriage.
Yeah.
So whilst we were doing the will, we checked all the paperwork and we're like, you are not married according to this. And they're like, what are you talking about? So we said, you need to go back to the marriage registration office and you need to recheck if this has been registered. And they did. It wasn't registered. So they've had to go and sign that piece of paper again to make sure that everything is in force. Fortunately, because we were there and we had this conversation, even though they've gotten married again, the will is not void because we put a clause in there to say that marriage will not void this current will. So these are the little things. And I know, you know, they're not big things, but they have a big impact.
Impact on
So
it.
any will that's made before marriage, marriage voids a will automatically.
Thanks, Nirali.
Very minor thing, but very major at the same time.
Thank you, Nirali. A couple of questions have come through. Someone's asking, is there how much does it cost to do a property protection trust under a will? I'm guessing, Matthew, that's the fee that you mentioned of £310 for an individual and £390 for a couple, or is it an additional cost?
So that's the basic will.
Yeah.
That's the basic will. If you're doing a property protection trust,
Yeah.
one of the things you have to make sure is that the principal property that you're looking to protect is owned in what's called tenancy in common and not joint tenancy. Now, the vast majority of properties are owned as joint tenancy because that's the default that conveyancing solicitors do if they don't ask. That tenancy needs to be it needs to be severed. So you do a severance of tenancy and you change it from joint tenancy to tenancy in common. Joint tenancy, the couple owns 100% each together. Tenancy in common, you own 50% each. That's how you put 50% in the property protection trust. So all that being said, the cost for a basic will with the property protection trust and also a severance of tenancy, which we need to do 99% of occasions, for a married couple is £970.
Yeah, thank you. And the question was asked whether if you've got a will and you want to update it, is it classed as a new will or you only pay for an update?
So both. You will get a new will because it's much better and more legally clear than doing a codicil. So you would get a new will, but if we'd done your will previously, then we would just charge a small fee as an update. And that would be dependent on what was changed and what was amended within the will.
Thank you. That's an interesting question. I may get the person to explain themselves a little bit, but it says, is there something called a prenuptial agreement? And I think that was more for marriage and splitting of assets, but is that what you mean, Bruffle?
That's for a family lawyer, but there is something, it's a prenuptial agreement.
Yeah.
However, what's very interesting in England and Wales, they're not legally binding.
Oh,
So sorry to anyone who's got one.
so I have I have a case study for you then, Matthew and Nirali.
Oh dear.
You know, we like our families to grow, and we sort of expect our children to get married. And let's say for some reason, you know, we're not overly keen on the individual that our child is marrying. But we want to preserve our assets a little bit and sort of keep it away from the you know, the new person that my son or daughter is going to get married to. What can I do about this?
Good question. So there's a few things that you should do. In the will, it would only specify gifting to your lineal descendant. It would, in the will that we prepare, it would then also say, should that lineal descendant predecease, then who it goes to. What we would also suggest is that the person who inherits makes a will straight away. And we're going through this with a family at the moment where there is very delicate family relations and they don't want it to go to certain members of the family. So the person who is due to inherit would make specific instructions in their will about what they would do once they've received that asset. Yeah.
Again, very complex, and you know, our advice to everyone on the call: please reach out to Mahesh through Mahesh. Reach out to Matthew and Nirali. We're running sort of
I'm
short.
I'm just gonna add something in there that, if you
Yeah, please.
know that, things are going wrong, divorces and separations don't take place overnight. They take months, they take years, and it's a constant nag. If you know that things like that are happening, either try and this is where the life trust comes in play. You are protecting your assets. This is where, if you know things are happening, there are parents or family members or brothers, sisters living in that property that you own, try and start moving that. So
Great
it's
advice.
constant work, basically. That's
Great
what I'm saying.
Great advice. Like I said, we're running sort of short of time, but I wanted to give Mahesh an opportunity to say something, add any comments. Mahesh, do you have any other thoughts, comments?
Yes, a couple of observations. First of all, for Matthew, when choosing executors, from experience, our family, or Indian families I'm talking about, they normally choose two executors, son and daughter or whatever, and the daughter eventually gets married, then moves out of the country, goes overseas and all that. But she still remains as part of the executor. But when it comes to administering the will with the various authorities and whatnot, it becomes extremely difficult for them to communicate with a person overseas. So in that case, anyone who has this situation like that, they must readdress the will and change their executors to make sure they are in UK. So it's easier for the surviving people to handle the matters much more easily. That's one observation. The other thing is, again, regarding the wills and all that, amongst Indian families and whatnot, usually you have situations where a son gets married to a girl who is not liked by the parents, by the father's parents and whatnot. And in a situation like that, and say, for example, if both the son and daughter die in a car accident, and before that, the son's father has invested a lot of money in the property and whatnot for the son and them. then if that situation goes into interstate, the law will say that the wife died 1 minute later than the husband, and that means the whatever the estate is, the whole estate will go to the girl's parents, and nothing will come to the boy's parents. So that is another issue must bear in mind, that yes, it's very important to make a will as ASAP. Third issue is, this is my live case, is about my family, my father. My father made a will before he got married, and this is going back 1948, 49. And in his will, he stated that his estate will go to his four brothers. He then had a life insurance policy of 75,000 British pounds in those days, a lot of money. And obviously, my father did not know that he was going to die so soon. Within 10 years, he died in a car accident. He had never changed the will. My mother was completely illiterate. She had no recourse what to do. She didn't even know that there was a will and there was an insurance policy. And unfortunately, with the help of the will and whatnot, my uncles got hold of the funds, and that's it. We were left high and dry. That's life situations. So when you do make a will, do make sure that if any changes in your lifestyle and whatnot, make sure that you change the will and keep it up to date all the time. That's the main point. And lastly, estate planning. We mentioned, like I mentioned, there were three issues. One was making the will. That's what we were talking about. Secondly was to make life easy for your beneficiaries. That's where we come in. But everyone's situation is completely different, so it'll be discussed on a one-to-one basis. And thirdly, checking on what kind of tax liability you would, your beneficiaries would incur in case of for inheritance tax. Again, this is where we come in. We help you out and see how we can best mitigate inheritance tax in the best possible way. And yes, I think that's the session has been very successful, I presume.
Yeah, it has. I think everyone has sort of come back saying they're learning a lot. I think, not that I think, I know this is very, very complex, and we've covered a lot of information in a short period of time. Okay. People have asked the question, is there a replay of this discussion? Yes, there is. It's on YouTube. Prana's kindly posted this on our chat, but also we have a WhatsApp group where we post all our weekly webinars too. Prana, you have a point to make?
Yes, one last question for me. I've made a lasting power of attorney for my sister. Do I need to upgrade that?
When you say upgrade that, what do you mean?
Well, we did this lasting power when my mom passed away.
Okay.
My sister is mentally handicapped, so
Okay.
we did the lasting health and wealth, both lasting. And I just wanted to know, do we have to go higher up, or it stays as it is done?
So just a couple of questions there. Who is the power of attorney for?
My sister.
Okay, so your sister, does she have mental capacity to make the change?
No. So
Then-
I myself and my younger sister has the power to do the changes and look after her wealth and the health.
Yeah, so no, you cannot make the change. So any person that's deceased, you can send the power of attorney back to the Office of Public Guardian, letting them know.
No, but we had it done. After
Yeah.
mom passed away, we had it done, this lasting power, because to look after her.
Okay, so when you do a lasting power of attorney, a person that is giving the permission to the attorneys to do the lasting power of attorney should have mental capacity to do so. You cannot do it otherwise. If you've applied for a deputyship, which is very different, which is where the Court of Protection actually gives you permission to manage someone else's finances, and then there is a yearly accounts and stuff like that that you have to submit, and there's a yearly fee that you have to pay. They're two very different things. So you cannot do a lasting power of attorney for someone that has lost mental capacity or does not have mental capacity. That's the first point. The second point is that if someone has passed, so if, say, for example, I did a power of attorney and I've put mum on there and I've put my two sisters on there, and mum has passed, then that's not a problem. It won't affect your power of attorney. All you need to do is send that power of attorney back to the Office of Public Guardian to say that this specific person has deceased. All they do is they will stamp on that page where the deceased person details are. They will stamp on there to say person deceased, not authorized. And they will send it back. That's what they do. That's on a normal lasting power of attorney. If you've done an enduring power of attorney, which we used to do years ago, that only worked on property and finance, that is still valid, but only works on property and finance, does not work on health and welfare.
Okay.
Does that answer some of your questions?
So I think Bana's question, Nirali's answer says a lot to everybody, actually. So what it says to me is that everyone's circumstances are so different. It just, Nirali's answer sort of highlights how complex this is. And, this goes back to everyone's circumstances are so different. You have to seek individual advice. These calls are great for general discussion, but when we get into our own circumstances, the advice really is reach out to Mahesh, reach out to Matthew, reach out to Nirali, because things will get missed. And unless you have a proper discussion, you're not going to be in full control of your finances in your future years. Okay, so I'm just going to sort of summarize very quickly because I think we've gone over the hour.
Before you summarize, I just want to say one thing. Lasting power of attorney ceases the moment someone passes. So it's not valid after someone passes, just so everybody knows. Will come into effect when someone passes. So they do work side by side, just that one is when you're alive, one is when you pass. Just wanted to say that.
Yeah, and it's interesting you say that, Nirali, because I think people do get confused.
Yes.
Yeah, so powers of attorney are there for when someone's alive. Once they pass, unfortunately, the authority under the will take over. So I think it's good to note that. My closing was very, very simple, actually, which is, well, I liked what Matthew said at the beginning, and have that consultation. You need to have your affairs in a little bit of order. So what are your assets? Have that discussion with Mahesh. Mahesh will definitely put you in touch with Matthew and Nirali. What they're going to do is find out what you want to do with those assets. Okay, and people, don't forget, assets includes everything. People talk about property, which is our biggest asset. People are holding a lot of cash. People are holding investment properties. People are holding jewelry. People are holding artwork. People are holding cars. So what do you want to do with your assets? And everyone's got a different requirement as to what they want. Okay, and the third and most important question that sort of came out from Matthew's discussion was why what do you want to do with the assets, but why do you want to do that? So there's an understanding there. Based on that, people get proper guidance. So what are your assets? I hope you've all got spreadsheets and you've shared them with your children. I know we haven't, but we should. Okay, because as we said, the taxman and the legal teams will find out first. So what are your assets? What do you want to do with those assets and why? And reach out to Mahesh. You lose nothing. He's giving you free consultation, and if there's a policy, etc., that fee that you incur gets absorbed. Matthew and Nirali have given us great reasons why we should have legal counsel here. So please reach out to them. And with that, I sort of want to close the event and say bye to everybody.
Thank you. Hannah, do get in touch.
Yeah, and someone's asked for your contact number. So what we'll do is we'll send around on our WhatsApp. If you're not part of it, please reach out to Pana or to me. We'll add you to the WhatsApp. We'll contact details. We'll put Mahesh's contact details on, AWP's contact details on, and it'll also give you an idea of, as to our future webinars. We have the next one next Thursday. It's every Thursday, and we're going to have a team from Imperial College talk about osteoporosis and dexterity. So it'll be quite interesting. And I think we are going to be talking about financial well-being in the future again to cover maybe the similar topic, but just repeating it as well. Yeah. So look forward to seeing you guys, everybody next week. Stay well and stay safe.
Thank you.
Thank you very much. Bye-bye, everyone.
Thank you.
Thank you.
Bye-bye.
Goodbye.
Bye.
Thank you. Thank you.
Bye-bye.
Thank you. Thank you very much. It was very interesting.
Most welcome.
Thank you. Very interesting.
028 number. 028 429 0290.
Thank you very much.
07.
Thank you. Very informative.
Yes, it is.
Left.
Left.
Yeah, it's 07958 058 113.
Take a screenshot.
Yeah.
Screenshot. I did that thing of that.
And we'll send this around as well, because I think it's sometimes a lot of information to take in. But
Yes.
I think we need to get Nirali and Matthew's numbers as well put up.
Yes.
Or Mesh, can they go through you to reach them?
Yeah.
Yeah. Okay. Okay. So if you go through, oh yeah, thank you. We'll go through Mahesh if you want to get in touch with AWP. Okay. Thank you, everyone. Have a good evening.
Thank you.
Thank
Bye-bye
you,
now.
Nirali and Matthew and
Bye-bye.
Mahesh Bhai. Thank you very
Thank
much.
you. Thank you. Bye-bye. Bye-bye.
Have a lovely weekend.
Bye-bye.
Bye. Thank you, Kamlesh.
See you.